Good morning, everyone. I'm Ravneet Kaur, and we are going to explain, and we are group number 9, and we are going to explain business law assignment. And Gurpreet is going to start the questioning on the law, on the contract law, and there is issue in between John and the car parking. So Gurpreet is going to explain that. Thank you.
Hello, my name is Gurpreet Kaur and now I am explaining question number 4. I am explaining issues, rules and application of that questions. And this is the issue between Johns and car parking company. And the issue lies between two parties as Johns and a car parking company regarding the term and conditions mentioned in the contract. John drove her car in the Smith's car parking area through the mechanical parking. There was a signboard which carries the detailed information about the conditions of parking and also the liabilities of company in a car in the case of the injury occurred during the premises. In this part, the fact is identified as it's whether the car parking company can completely rely on the assumptions clause to protect them from any action undertaken by the Johns. And in the rule applicable in this is contract law. In contract law, is just a contract, and I am describing something about the contract law. It's consider the legal informant that made between the parties to agree with some terms and conditions that can either be expressed or impelled. To enter into the contract, the parties must be competent and handle the terms, and also the contract is made based on the consideration. And in the applicable, the car parking company can successfully rely on the assumption clause. And in the conclusion, the contract is valid and the car parking company is successful in the assumption for not having any liability to pay any damage. If all the terms and conditions mentioned in the ticket, no party can claim for any losses. For the next part, my one of my friend can explain.
Hi, my name is Hardik and
It's a part B.
I'm gonna explain application. So by applying the above case in the present scenario, the matter reflects that car parking company can successfully rely on the exemption clause. Firstly, in the case of Oliver, the decision of the court reflects that there is trust and performance committed between the parties. By reflecting the case with the present case, the matter is the same. All conditions are mentioned in the tickets and also conveyed to Jones. In the case of Australian woolen mills with Commonwealth, the breach was faced regarding not fulfilling the terms and conditions mentioned in the contract. But in the case, all the conditions is mentioned in the tickets and also is displayed at the premises. Thus, no liability is imposed upon Jones to filed suits against the car parking company. In the third scenario, the owner clearly states that the injuries caused at premises are not their liability. The court also supports the decision in favor of the owner. Applying this judgment, the present case proves that no claim is given to Jones and for damages. At last, the judgment was given in the case of Australian Competition and Consumer Commission are also in favor of the car parking company, as if they clearly mentioned the terms in the ticket and also conveyed to parties, then no liability is imposed upon the company to pay the damages. So let's talk about the conclusion. From the above study, the case concludes that the contract is valid if it fulfills the basic elements such as offer and acceptance of the terms, the intention of the party to enter into contract, competent parties, and capacity to fulfill all the terms mentioned in the contract, and also consideration. Thus, in the case, the car parking company is successful in the exemption regarding not having any liability to pay damages. So now we're going to talk about part B, summary of the president and issues identified. The law of tort is described as the civil that comes into the force when an individual breaches the duty of owned to other individuals that may cause injury in any aspect. The report has been presented with the IRAC approach of a selected case study. Some example of the case of negligence have been demonstrated for a better understanding of the concept and supporting the given case law and decision. Summary of the report is the Edward got injured while riding a bicycle on the private land of col- Consolidated Broken Hill Limited. The plaintiff claimed that the injury had been caused for the reason of no barriers and the parking of 20 rail wagons on the short branch line of the bridge. The plaintiff tried to cross the bridge from the small gapping between the wagons and the solid edge of the bridge. Edgar's jumpers was caught in the wagons and ultimately led to the fall of the bridge, and plaintiff was claimed himself to be devoid of any risk while crossing the bridge. The plaintiff is able to get the decision in favor, but but a shared liability due to contributory negligence. So, issues identified in this are the premises issue that is addressed is concerned with the liability in negligence by Consolidated Broken Hill Limited, which has allowed to trespassers to take the issue that has been identified in the case law is negligence of the defendant to park the rail wagons. The defendant has been at a loose end for the reason for that the person entering their private land was allowed by them without any obligation. Edward has been booked by the contributory negligence and therefore apprehended liability. The portion of Edward and Consolidated Broken Hill Limited has been decided 1-2 respectively. Now my friend Ravneet is gonna talk about rules applicable.
So the rules and applications. So the civil liability, according to the Civil Liability Act 2002, the the legislation cited for the resolution of the issue has been Civil Liability Act 2002, Section 5R of the Civil Liability. So provide the base of for the case of the Consolidated Broken Hill Limited versus Edward. So the concept of the contributory negligence has to be applied. So it said that the behavior and the actions that contribute to the loss or injury of an individual do not suffer the standard of the prudence, which is expected as a part of the good behavior. So according to the section 5R2 provides reasonable grounds for the standards of care to be taken by the plaintiff. The standard of a care of Edward should have been equal to that the rational and a reasonable person in terms of the knowledge and the place of facts. So according to the subsection 231 in this section, also clearly present and the fact that the rules and principles that are applicably and the grievance of the faulty party should be the judicially applied to the person who has been injured in the incident to the uncertain whether the plaintiff is also contributing negligent in adopting and precautionary measures for the mitigating the risk rule factor. So after that, I'm going to explain the application for this. The Consolidated Broken Hill Limited versus Edward can be compared to the suit filed case as Candid versus Queensland Aluminium Limited. Uh, the faculty study of the case reveals the essence of the contributing negligence for the plaintiff and the defendant. Paul Candy, who has been engaged as a worker for the Candid versus Queensland Alumina Limited, suffered an injury while working in the corrosive material that may cause burns on the skin. The caustic solution present in the pipe splashed out of from the pipe, and the left heel ankle Paul were suffered burnt. Paul filed a suit against the firm for the fact that the caused negligence of the worker's safety. The firm defended itself with the fact that the Paul was faulty for the incident as he was unable to comply with the training section of the working safety and pipes. This has been case of contributing negligence. So after that, there is some other as well cases versus Phillips versus Tallis, Romeo versus Commission of the Northern Territories, Thompson versus Queensland, Woolworths Queensland Permitted, who also spotted Consolidated Broken Limited. So in the next slide, I'm going to explain the confusion between the Mr. Edwards board entitled to claim compensation of $91,000 billion. So the appeal from the plaintiff is upheld and the judgment was verified. July set aside, Mr. Edward has been entitled to claim compensation to a sum equals to this. Also, Mr. Edward is responsible for making the payment of the cost and care of raising the appeal. He also awarded as a certificate under the suitors. The trial judge finding have been yielding to the following outcomes for the case law between Consolidated Broken Hills versus Edward. The people who use their private land as their shortcut way were indeed the trespasser, including Mr. Edward. It was a responsibility of the Consolidated Broken Hills to owe them to the duty of a care. Edward consideration as a trespasser is correct in terms of content of the duty, but the knowledge of Edward taking the advantage turn the stone for the Consolidated Edward. So the risk of approach headed by Edward was obvious. Still, the tendency of Consolidated Broken Hill Limited to park the wagons at the edges had a high probability of harm in case of carelessness. The judge concluded that the risk could be avoided if the parking of the rail cars was systematically done. There was no point in the challenge to the fact that Consolidated Broken Limited has breached its duty care it was on to the plaintiff. So there are some other references which is just showing on your screen. So we get some ideas for our assignment, and hopefully you like the assignment, and thank you so much.